us to this story now. The Judicial Inspectorate for Correctional Services has presented the idea of a bail fund to Parliament's Portfolio Committee on Correctional Services this week. Now, the Inspectorate has described the fund as a non-state resource that would provide bail assistance for low-risk detainees. Joining us to unpack this, is Sohela Surajpal, legal researcher at the Judicial Inspectorate for Correctional Services and also law clerk to the inspecting judge. Good afternoon, Sohela. Thank you very much for joining us on Point. Now, this bail fund proposal that you guys have presented to Parliament has sparked interesting debate. I mean, we've been monitoring quite closely what's been happening, mixed views from many in society. Let's start with just the clarity on what exactly the bail fund seeks to do.
Thanks so much for having me, and you're right, it is it's a controversial thing to speak about. At JICS, we've been concerned for a very long time, and we think the Department of Correctional Services, members of Parliament share our concerns about the number of people in our prisons who have been granted bail, which means a court has determined that they will show up to their trial, they will not interfere with witnesses, they don't present a threat to others. And very low bail amounts, in particular, we monitor people who've been granted bail of less than 1,000 Rand, but remain in prison for extended periods of time simply because they cannot afford those very low amounts of bail. We call those people prisoners of poverty, and we've seen people who've stayed in prison for months because they can't afford bail of 200, even 300 Rand. Mm-hmm. And so this is obviously an injustice to those people who, if they had money like us, or what might seem like a trivial amount of money for us, would be released, would not be incarcerated. But it also contributes to the very serious overcrowding problem in our prisons, and that's what we want to address. So the idea is you have philanthropic funds, not paid for by taxpayers, that we would use to very selectively sponsor bail for low-risk inmates not accused of serious violent crimes, especially gender-based violence or domestic violence. Mm-hmm. And that would allow them to be out of the prison system while they stand trial and while we determine whether they are in fact guilty of the crime of which they've been accused. Mm-hmm.
That was actually going to be my next question around the category of criminal offences, because for many, I think that is where the controversy would come in, that if somebody is accused of GBV, then do people help to fund and allow them to be released on bail, especially because right now the division is probably also around this bail fund, is probably also around the timing. Society is still discussing the element of bail being granted to certain suspects who go on to commit other crimes, even more heinous than the ones they had committed or been incarcerated for initially. And one case in point is Olerato's case. It speaks exactly to this. So when we speak of the categories, have you clearly distinguished now that you've got GBV cases, any type of violent crime, which other categories will be excluded from this fund?
So I think the first thing to say is that this is a very legitimate concern. As South Africans, we have serious and justified worries about crime, about violence, about our safety, and certainly as women, but I think as all South Africans. And so we are taking those concerns really seriously as part of this effort. Mm-hmm. We, from the outset, have known that gender-based violence and intimate partner or domestic violence would be one of the categories of crime that would exclude a person from benefiting from the bail fund. We have other ideas. For example, we might consider seriously violent crimes, murder, obviously rape would fall into the earlier categories that I've discussed, but we haven't yet concretized those, and that's because this bail fund is still at a very early stage. So we have completed a feasibility study where we've been consulting widely with experts in the field. We've presented the idea to Parliament, and we're now working on launching a pilot project. So we are establishing a trust which would then determine concretely those eligibility requirements, who would be excluded based on crime, what our sort of upper limit in terms of bail amounts would be. And that would also be dependent on the way the pilot project works, because the point of a pilot project in a single region, in a single prison, is to figure out what does this problem genuinely look like on the ground, not just in our research, but on the ground, what works and what doesn't. But it's definitely a question that the portfolio committee posed to us, took very seriously, and that we are in turn taking very, very seriously.
I suppose then even the debate outside of Parliament will also be to your benefit, because it will help you, as you say, concretize this specific plan.
Absolutely.
But now, in the process, at least for now, what you've drafted, in the process of selection, are you envisaging a situation where you'd also then interview the family members of the person who's currently in prison? Because there could be instances where families actually have the money to get their loved one out on bail, but perhaps that family member has been terrorizing them. This is a moment of peace for them. So would you be looking to even interview them in that process?
Again, something that was raised to us in Parliament recently and that we thought was a really important point. We do sometimes hear of inmates whose family don't want them released, often inmates who are struggling with addiction and who can become a nuisance or can make their families uncomfortable in that way. And so we do envisage that before allowing someone to benefit from this, we would consult with the people who are meant to act as their support structure upon release, because as I'm sure you know, when someone is granted bail, they do have to prove that they have a fixed address. And for many of these people, that would be the house of their family. So to a certain extent, that is considered by courts already, but we would in turn also consider it. And take that seriously. I do want to make the point, though, that the fact that your family doesn't want to help you or doesn't like you very much is not sufficient reason for you to be deprived of your liberty. Of course, when that rises to the level of you presenting a risk or a threat to your family, that's when we'd need to take it really seriously, and we absolutely will figure out how we can implement that most effectively.
All right, Sohela, we'll be monitoring the pilot project. Thank you very much for joining us on Point. That's Sohela Surajpal, legal researcher at the Judicial Inspectorate for Correctional Services. She's also a law clerk to the inspecting judge.